Hello, good morning, good afternoon to all of you. I'm Marcy Koski, and I am the chair of our Husch Blackwell Consumer Financial Services team. Before we get into the good stuff, let me cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webinar, please submit via the question box. We will try to answer all of your questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later by email, or of course you can always email us directly. A PDF of the presentation will be available in the program materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We will use your feedback to plan future programs that are applicable to you as you navigate the regulatory scheme in Wisconsin. So to move on to our speakers today, first of all, as many of you know, HB is a national full-service law firm. In addition to representing lenders and others in the financial services space in Wisconsin, we also represent them across the country in both state and federal matters. Joining me today, we have Elisa Lawless, Natalia Cruz, and Kat Albrecht-Weezy. Lisa and Natalia are our top-notch litigation attorneys representing lenders and others in state and federal court and in arbitration proceedings. They regularly defend companies and lenders in Wisconsin Consumer Act and other consumer laws in those types of cases. Our litigation team has an excellent track record of success, including favorable settlements. Additionally, we've been very involved in high-level litigation in the state, litigation that has shaped the consumer finance law here, including the recent Wisconsin Supreme Court decisions in Security Finance versus Husch and Duncan versus Asset Recovery Services, both of which we will talk about today. Kat is a regulatory compliance attorney who helps our clients develop proactive compliance strategies to assure compliance with the Wisconsin Consumer Act while also allowing a client's business to flourish. Our experience in representing clients both in litigation and in regulatory compliance matters allows us to give us advice on Wisconsin law, considering the broader context of the landscape. This in turn helps our clients to proactively avoid trending issues that are trending here on the ground. That's all for our housekeeping matter items. Let's get started with our program. Okay, so I'll just give you a roadmap of what we'll be talking about. First, we'll give just a general overview of the Wisconsin Consumer Act, do some level setting. We'll talk a little bit about deferral agreement and delinquency charges, get into the meat of some notice of cure requirements and litigation on such requirements, repossession under the Wisconsin Consumer Act and liabilities that may be associated therewith in the event of a quote-unquote unlawful repossession, recovery of deficiency after sale of motor vehicle collateral. We'll also talk about the Wisconsin Consumer Act's debt collection statute and unconscionability under the Wisconsin Consumer Act, which are claims that we often see in litigation here in the state. We'll touch on some national bank preemption issues and then end with some questions if we have time. So to kick it off, as many of you know, the Wisconsin Consumer Act applies to consumer transactions in the amount financed of $25,000 or less. The Wisconsin Consumer Act is a consumer credit code that is of general applicability, meaning that it applies to all lenders who are offering products that are subject to the Wisconsin Consumer Act. So it applies to banks, credit unions, and non-bank lenders, auto finance companies, etc. As pertinent to our discussion here, which is revolves around servicing and collection, we've identified some particular statutes that are of importance. First of all, the Wisconsin Consumer Act has a particular definition of default that lenders need to be aware of, and that definition of default drives whether and when a notice of right to cure is proper. We also have, as mentioned, a notice of right to cure statute that delineates specific items that must be contained in the right to cure. There are requirements, limitations, and liability associated with repossession of collateral. That is probably our number one litigated statute under the Wisconsin Consumer Act, in addition to the debt collection statute. There are also venue requirements where you can file a lawsuit and where the failure to file a lawsuit in the right venue is improper. And then, as mentioned, we have a debt collection statute. These are often asserted in connection with other alleged violations of the Wisconsin Consumer Act and can, quote unquote, raise the price of poker because a plaintiff can get emotional distress damages. Finally, it's a fee shifting statute, so reasonable attorney fees may be granted to a consumer's attorney if a violation is determined. All right, so there is a deferral agreement requirement under the Wisconsin Consumer Act. So the statute, and many other states have a similar statute. In Wisconsin, the statute was intended to apply to pre-computed loans. A pre-computed loan is one in which the customer agrees to pay the total of payments at the outset of the transaction. So the scheduled interest is determined, and that is added to the principal balance, and the customer agrees to pay that total amount and no more or no less, except if they repay early, and then there are refunding requirements. This is in contrast to an interest-bearing loan where a consumer agrees to pay the principal balance plus interest as it accrues on a daily basis. That is, if there's a payment that is missed or late, additional interest will accrue on that principal balance and the customer will be liable for it. The customer agrees to this, of course, at the outset of the transaction because they're agreeing to pay principal plus interest as it accrues. In contrast, in a pre-computed loan, because the customer has agreed only to pay the scheduled interest, if a customer misses a payment or pays late, the lender will not be able to get any additional interest. So in steps the pre-computed loan, the deferral agreement statute, which allows a lender to charge a deferral fee to a customer to defer a payment in a pre-computed loan transaction. In order to do that, the lender and the customer must agree to it, and that agreement must be in writing. And that makes sense because in the original transaction, the underlying transaction, the customer has not previously agreed to pay that additional fee. They've agreed only to pay the total of payments. Again, this is in contrast to interest-bearing, where somebody has agreed to pay interest on the principal balance as it accrues from time to time outstanding. DFI long took the position that a deferral agreement was required in connection with both a pre-computed loan and an interest-bearing loan. The information required to be contained in the deferral agreement, however, is a little difficult to include when it is an interest-bearing loan. And it's sort of like fitting a round peg into a square hole or a square peg into a round hole. We recently had the opportunity to push back on DFI's longstanding position, pointing to the plain language of the statute and its history, and also commentators that were on the ground when the WCA was enacted in their interpretation that this particular statute was intended only to apply to pre-computed loans. After articulating that very strong legal position to DFI agreed and rescinded its position that the deferral agreement statute also applies to simple interest loans, which we thought was a very good outcome for the industry.
And I worked on this with Marcy as well, and the DFI cited the sections of the WCA requiring written disclosures, written agreements, the 422.302, but we argued that relates more to the initial loan agreement with the customer, and it says that things need to be in writing where you're imposing a separate charge. But nothing in 422.302 relates to the situation when you have a simple interest loan, and we argued that that allowing customers more time in the simple interest situation is more of a forbearance. It's not a deferral under the WCA, since no deferral charge is imposed. And we argued that there's no requirement in the WCA, all the sections of it, that a forbearance be in writing. And perhaps that was one of the arguments that persuaded the DFI to withdraw its long position.
Agreed.
So getting back to the requirements under the notice of cure requirements under the WCA. Under the WCA, before a creditor can accelerate a debt or start an action on the debt, the creditor must first provide the consumer with a notice of default and right to cure, and then provide them with a 15-day right to cure period. The notice of the right to cure must contain the creditor's name, address, and telephone number, a brief identification of the consumer credit transaction, a statement of the nature of the alleged default, and a clear statement of the total payment, including an itemization of delinquency charges or whatever other performance is necessary to cure the alleged default. The exact date by when the amount must be paid or the performance must be tendered, and then the name, address, and telephone number of any person to whom payments must be made if it's other than the creditor. And then the the consumer has 15 days in which, after receiving the notice, in which they have the right to cure the default and pay any unpaid delinquency or default charges. And the notice of right to cure under the Wisconsin Consumer Act is really a procedural requirement that is a procedural requirement to commence an action after default. And the Supreme Court affirmed this in a case that we'll be talking about later in this presentation, Security Finance v. Husch. And being a procedural requirement, what that means is that a failure to send the notice before suit is grounds to dismiss the collection action. It's a defense to just dismiss the collection action without prejudice and go from there.
Thanks, Kat. Was on mute. One of the requirements for inclusion in the notice of right to cure is itemization of any delinquency charges. And sometimes we see arguments that a notice of right to cure is defective and ineffective because it didn't itemize certain charges that the lender imposed. The question is, what is a delinquency charge? That's the only thing that the statute requires to be itemized. And under 422.203, the Wisconsin Consumer Act defines delinquency charge as, with respect to a consumer credit transaction other than one pursuant to an open-end credit plan, the parties may agree to a quote-unquote delinquency charge on any installment not paid in full by a certain date. The Crown Asset Management versus Al-Barani case that came out in 2022 by the Court of Appeals. It's a decision that's authored by the judge signs it, but it's not considered controlling precedent. It comes from the small claims court. It may be cited as persuasive authority in Wisconsin courts. In this Crown Asset case, the issue is, how do you treat fees for late payments on an open-end credit plan? That case involved an action for collection under a for non-payment of payments under a Sears MasterCard. So it was an open-end credit card plan. The consumer in that case argued that the notice of right to cure was ineffective because it didn't itemize late fees that were imposed on the account for the customer not paying his payments on time. The court considered whether late fees in an open-end credit plan are the same thing and should be treated the same as delinquency charges that have to be itemized under the notice of cure. And the court, in a pretty detailed decision, analyzes the different statutes and concludes that no, late fees under an open-end credit plan are not the same thing as delinquency charges. Delinquency charges are defined by definition to apply to closed-end credit, not open-end credit. The statutes of the Consumer Act allow additional charges to be imposed in open-end credit plans. For example, it authorizes quote unquote charges for late payments. In Crown Asset, the court held that quote unquote charges for late payments must be interpreted as different than delinquency charges, which have to be itemized. And the court reasoned that nothing in the Consumer Act states that a late fee on a credit card, an open-end credit, is a quote unquote delinquency charge that has to be itemized on a notice of right to cure. And so the court held that the Consumer Act doesn't require charges for late payments to be itemized on the notice of right to cure. This is the position that we often took based on our interpretation of the statute. And we're very, very happy that a nice, well-reasoned court decision agrees with us, and we can cite that in other cases as persuasive authority. Natalia?
One quick chime in on this one. So the court got it right here. I mean, the plain language of the statute distinguishes between delinquency charges and not delinquency charges. And this is important, an important decision, because the way that late fees are added to a principal in open-end credit transactions. It's very difficult to figure out exactly what are the late charges to be itemized in a right to cure when it is a transaction that is a credit card transaction or another open-end credit product.
Thanks, Marcy. Natalia?
Yeah, thanks, Lisa and Marcy. Okay, so kind of tying into a notice of right to cure, and oftentimes it's required to be combined, is a notice regarding repossession. So under Wisconsin law, a vehicle cannot be repossessed through self-help repossession until 1, the customer is in default, 2, a notice of right to cure default and a notice of intent to repossess is given to the customer. And then also after the customer has time under the statute, they do not cure their default or raise any written objection to self-help repossession. So Marcy mentioned earlier that the Wisconsin Consumer Act has a specific definition of default. And for transactions that are secured by a motor vehicle, that's when the customer has outstanding an amount exceeding 1 full payment, which has remained unpaid for more than 10 days. So if a payment is due December 1st and they miss that payment, and then there's a January 1st installment that they also miss, the customer would be in default more than 10 days after that, which would be January 12th. So if a customer is in default, you send the notice of right to cure default, which Kat talked about, and that notice of right to cure default gives the customer 15 days to cure. And then if you want to repossess the vehicle through self-help repossession, the creditor also is required to give the customer a notice of intent to repossess. And that requires a statement that the customer can, within 15 days after the notice is given, demand in writing that the creditor proceed in court to take possession of the vehicle instead of taking it through self-help repossession. So in other words, you have to give the customer 15 days after the notice of right to cure before any repossession efforts can occur. And then if the customer has both the right to cure their default and the creditor wants to proceed with repossessing the vehicle, those 2 notices need to be combined under the Wisconsin Consumer Act. And the really important thing here is that the remedy for not giving proper notice or for breaching the peace, which we'll talk about in the next couple minutes, is really extreme, and it's what we call the jackpot remedy. And if the jackpot remedy is available, the creditor needs to return the vehicle, or the customer can keep it if they already have it, and then release the lien. You have to refund all the payments that have been made under the contract if the customer has made any. And then you also have to waive the remaining balance, and attorney's fees are available. So it's a really extreme remedy, and that's why it's so important to keep these notice requirements in mind, and then also be aware of the case law that's out there on breach of the peace. And then just one final note, if the notice of intent to repossess is sent by certified or registered mail, then under the statute, it's presumed given. And if you violate, or I guess it's not technically violate, but if you don't send it by certified or registered mail, you send it through other means, that would not result in the jackpot remedy. It would result in a different remedy, which essentially is a $25 penalty.
Although, of course, when you have to prove that you sent it in litigation, it is helpful to have sent it by registered or certified mail, because you can point to that. If you do not send by registered or certified mail, then you need to put forth facts that show that you did give it.
Yes, absolutely. That's a great point. So, like I mentioned, litigation in this space typically involves either a claim related to improper notice for either, the claim is the notice was never sent, or some violation within the notice, some information wasn't included that needs to be included, like Kat mentioned earlier. Or the other claims that we often see are claims related to the actual conduct during the repossession, and that's more so related to the repossession company or the repossession agent's conduct. But as we'll talk about, there are claims made against the creditor in those situations oftentimes too. So the first types of claims, notice, those are related to and are typically asserted against the creditor. And whereas the conduct related to the repossession is not as straightforward, and we've seen mixed results in terms of the argument that a creditor should not be liable for the conduct of the repossession agent. So, there are arguments against liability of the creditor in that situation, because the repo agent obviously is not an employee or an agent of the creditor. And also the creditor does not have any control or direction over the agent's conduct usually. And then the other side is, some courts have found that obligations under the Wisconsin Consumer Act are non-delegable. So they'll find in certain situations that the lender is still on the hook for the repo agent's conduct, even though they have no control over that conduct.
We have a few questions in the chat about one question, and this I've thought of this often too. Are there additional steps one should take if the certified mail is returned as unclaimed? We've seen that occur in cases where they send and secure by certified mail, but it's not accepted by the customer.
Yeah, and feel free to chime in, Lisa and Marcy, but we always argue that the plain language of the statute is very clear, that if it's sent by certified mail, meaning, it's sent, but you can't control whether or not the post office actually delivers it, then that's in compliance with the statute, and there's no further obligation to ensure that it's delivered. And if you receive notice that it was returned back to the company, oftentimes that's because the customer is trying to avoid delivery or rejects it, and there's really no way to ensure that it's actually delivered to the customer's hands. And under the statute, all that's required is to send it by certified or registered mail.
And someone else asks, oh, go ahead, Marcy.
Yeah, no, it would just give complete control to the borrower if that were the rule, that if they didn't accept it, then it wasn't considered given.
And someone else asked about, what about delivering the right to cure notice electronically, like through online banking, and showing that it was read? would that be effective under the statute, or has that ever come up that you guys have seen?
So that's a really good question. The same concept would apply, that you're required to give it, not confirm that it was received. We've thought about it in the context of email, and if you get proper e-sign consent and your e-sign consent, the consumer affirms or confirms that they're able to receive email, then that right to cure should be valid. Just the mere giving of it, the mere sending of it. I haven't thought about it in the online banking context where you're presumably sending an email that then points to the online portal and requires the customer to sign in and see that notice. I guess a plaintiff's attorney or a court could see that as a lot of steps and a lot of friction to giving the customer notice of their rights. On the other hand, I'm not sure that doing it that way, if you get proper e-sign consent, is necessarily improper. We would have to give some thought to that.
And someone else asks, can the notice of intent to repossess be on the bottom of the notice of right to cure and all in one document?
So the answer to that is they must be in one document if the customer has the right to cure. They must be combined. In situations where you are just sending a notice regarding repossession, which there are situations where that would occur, then of course you wouldn't combine it with the notice of right to cure if the customer does not have the right to cure. In other words, if the customer has the right to cure, it must be combined with the notice regarding repossession.
Thanks, Marcy. One final question, so we're all got our questions cleared. On the delinquency charges issue where you're supposed to itemize delinquency charges on the notice of right to cure, someone raises a good question. What does it mean to itemize delinquency charges? Should it include the total of delinquency charges assessed and the dates those charges were incurred? I think that's probably, it depends, or it depends upon who's making the decision, but the court or DFI or whatever. But do you have any thought on that?
We've always taken the position that the itemization requirement is simply to itemize the total charges separate from the other figures, that there are basically two figures that are required. The amount of total delinquency charges, one sum, plus the amount that is necessary to pay to cure the default. The DFI, strike that. Plaintiffs' counsel have in the past argued that itemization means each and every delinquency charge is set forth on the right to cure form. The way we've interpreted the form on the DFI's website and the way we interpret the plain language of the statute compels us to the conclusion that you do not need to itemize each charge separately. That said, if you're able to do that, you could avoid questions about that or claims about that.
Thanks, Marcy. Natalia, you may continue.
Thank you both. So yeah, just kind of jumping back in on the repossession issues. One of the cases that came out recently this year in the Eastern District of Wisconsin involved a situation where there were claims asserted against both the repossession company and the creditor related to the conduct during the repossession. And this was a case called Joswick versus Minnesota Repossessors, Inc. And like I said, it was in the Eastern District. And the general kind of factual background is that the vehicle had been repossessed. It was only for a weekend, and then the vehicle was returned to the customer. And that is because the customer had actually paid off the loan a few months before the repossession, but the repossession company did not know about this at the time of the repossession. So the customer asserted a case against the repossessor, and that's in federal court. And then there's a separate state court action that's pending against the lender. And in the federal action, the court ruled that the jackpot remedy that we talked about earlier really is can only be provided against the lender. and not the repossession company. So this is an instance where the court found that, you know, even though the lender is not involved in the repo agent's conduct, because of the facts here, where, you know, the loan had been paid off before the repossession, the court, you know, really focused on that and found that because the repossession company did not know that the loan had been paid off, it could not be liable for repossessing a car in those situations. And it went to a jury verdict here where the jury found that there was no liability under the Wisconsin Consumer Act for the repossessor, and no damages found by the jury for the FDCPA and conversion claims. And again, the court really kind of focused on the fact that there was no knowledge on the end of the repossession company, and any sort of liability would have to be asserted and collected from the lender itself. So then another thing we wanted to talk about is really the breach of the peace cases that we've seen recently. And the standard for the breach of the peace under Wisconsin law has been long established. It was established in Hollebusch versus Ford Motor Credit Company. That was in 1993. And the standard is when the customer unequivocally orally protests the repossession. So this, you know, it seems like a clear standard, but the determination is really fact intensive. So you see different courts come down on different sides, and arbitrators come down on different sides, just depending on what the facts were during the repossession. So a couple cases that we've seen come out in the past couple of years related to the breach of the peace standard. Just touching on briefly, this first one, it was Russell versus Santander Asset Bids Wisconsin and the repo agent, and really it focused on the conduct involved in the repossession here. So the facts really were that a debtor saw that his vehicle was being repossessed. He grabbed his gun and went outside and stood at the back of the vehicle while the repo agent was trying to disconnect the battery and repossess the vehicle. Some events occurred, and the repossession agent called the police to come related to the customer having a gun and threatening him. And the police arrived, arrested the customer, placed him in the police car. And while he was in that police car for about 20 minutes or so, the repossession agent then went ahead and repossessed the vehicle. So the customer asserted breach of the peace claims here. And the court held that the repo agent did not avoid a breach of the peace by calling the police to help after the customer had objected to the repossession. And there wasn't enough of a delay to constitute like a separate repossession after the customer was in the police car. So the customer won on summary judgment, and the repossession company, there was a breach of the peace there, and some claims asserted under Wisconsin Consumer Act, both under the self-help repossession statute and the debt collection statute. And then the court also did find in this situation that a creditor would be liable for the agent's violation, because in this situation, the court found that there was an independent duty on the creditor not to breach the peace, even though the creditor, again, did not have any involvement in that, in the factual situation of the repossession. And then the second case noted here, another breach of the peace case, plaintiff claimed that the repossession company, which was Phantom Recovery LLC, violated the FDCPA, and then also asserted Wisconsin Consumer Act claims. And here the repossession occurred. There was a lot of discussion back and forth between the agent and the customer related to how the customer could potentially avoid repossession or get their vehicle back. Really, that was the focus. And she had indicated that she was filing for bankruptcy. The repo agent went ahead and gave her some advice on how to get the vehicle back, which ultimately was not correct. And they misrepresented the creditor's policies and what the creditor would do under the situation that the repo agent was advising her on. So he repossessed the vehicle, and then the customer was not able to get the vehicle back after she had filed for bankruptcy. So she asserted claims, and there were cross motions for summary judgment in this case. The court granted the defendant's motion because they found that there were undisputed facts that, or the undisputed facts did not support a finding that plaintiff had protested the repossession, because the conversation was not an unequivocal protest. It was just trying to figure out how she could get the vehicle back if it was repossessed. And I'll pass it back to you, Kat.
Thanks, Natalia. So in addition to the prohibition against breaching the peace, Wisconsin's statute 425.206 sub 2b also prohibits a merchant from entering a dwelling used by the consumer as a residence, except at the voluntary request of the customer. And there's actually a case earlier this year in the Wisconsin Supreme Court that interpreted this provision of the Wisconsin Consumer Act. And the facts of the case are pretty straightforward. The debtor defaulted on her car loan, and the creditor started the statutory process for non-judicial repossession. The debtor lived in a multi-story apartment building where the ground floor of the apartment building was a parking garage, and she rented a space in that the parking garage, but it was a multi-use by tenants, you know, like a typical like large apartment complex with a parking garage on the ground floor. You needed keys to enter the residential area from the garage, and typically would have needed a garage door opener to enter the parking garage. But when the repossessor arrived at the apartment building to repossess the vehicle, they found that the garage was open. So they went in, located the car, and towed it away. And the plaintiff sued, claiming that the repossessors violated the prohibition against entering a dwelling used by a customer as a residence when they entered the parking garage. And this was ultimately the issue that was considered by the Supreme Court was when a repossessor enters a multi-tenant parking garage, did they enter the dwelling used by the customer as a residence? And ultimately the court held yes, that they did. So the court held that the garage was considered a dwelling used by the customer as a residence, and the court concluded that that because that the word dwelling in the statute included the parking garage because the garage was located in the building where the plaintiff lived. The defendants tried to argue that the phrase used by the customer as a residence limited dwelling to only the parts of the building that were integral to where the customer lived. But the court rejected these claims or this argument and said that that phrase only meant to distinguish the customer's dwelling from other dwellings. And so this ruling by the court was pretty significant. And it's significant for a number of reasons, but it's significant because it expands the potential exposure of lenders engaging in these repossessions by holding that a garage is included in the definition. The garage of a multi-unit residential building is included in the definition of a dwelling used by the customer as a dwelling. And it expands the universe of repossessions that will run afoul of the Wisconsin Consumer Act, and reduces significantly the opportunity for repossessors, especially if they want to avoid situations where the debtor is present, to avoid breach of the peace situations. And it's also significant because the violation of the non-judicial repossession statutes comes with the jackpot remedy, which are the steep penalties that Natalia mentioned earlier, where the debt is voided, any payments made by the customer must be returned, and the customer gets to keep the collateral. So just in light of this decision, and I believe it was January 2022 that this decision came out, just lenders and repossessors should consider adjusting their policies when it comes to repossession.
So
And
after a vehicle, go ahead.
real quick, and we might be talking about it later, but while that decision wasn't great, there are a couple of very good items that did come out of the decision, including confirming that notice of right to cure is not an action or other proceeding, which has helped in claims that the sending of a right to cure violates statutes that pertain to actions and other proceedings. And then also with respect to unconscionability, which I know we're going to cover in a little bit. Just want to put in that little plug. Thanks, Kat.
And it looks like we have a question related to that before we move on. Does the attached garage inclusion have any impact on collateral located in detached buildings on the same premises / property as the dwelling?
That's a good question, and I think it probably deserves more conversation than what we have time for today. So we'd be happy to answer that question in a follow-up call to the gentleman who asked it.
Sounds good. So after a vehicle or collateral has been repossessed, the next step would be selling the vehicle and then seeking any deficiency from the customer. And we've seen some recent litigation on this issue, but first, just as some background, the deficiency is, of course, the balance that is left after repossessing the collateral and then disposing of it and then subtracting it from the remaining balance on the account. So we wanted to highlight this because there's a difference between deficiency under the Wisconsin Consumer Act and then under the UCC. So first, under the WCA, a customer is not liable for deficiency unless the creditor has disposed of the goods in good faith and then also in commercially reasonable manner. And then if that's the case, under the WCA, a creditor is entitled to recover from the customer the deficiency, if any, remaining after deducting the fair market value of the collateral from the unpaid balance. Whereas under the UCC, the deficiency is calculated by deducting the proceeds of the sale from the unpaid balance on the contract. So just some difference in language and terms used there. They're not identical. And so just generally we've noticed there are some recent lawsuits claiming that UCC notices are insufficient for purposes of the WCA after the sale of collateral. And that stems from the language that we were just talking about on the previous slide. So just wanted to highlight that for your attention. And I'll pass it back to you, Marcy.
Great. Thanks, Natalia. So as we alluded to at the beginning of the webinar, there is a debt collection statute in the Wisconsin Consumer Act. Unlike the FDCPA, it applies to first-party creditors. Unlike the FDCPA, there's no particular notice or timing requirements. It's not nearly as prescriptive, if prescriptive at all, like the FDCPA. But it is important to recognize and know that it exists because plaintiffs often allege that a technical violation of one statute is also a violation of the debt collection statute. And as mentioned, they do that because a violation of the debt collection statute gives rise to emotional distress damages, unlike other remedy sections in the Wisconsin Consumer Act. There are various provisions within the debt collection statute that you have to abide by when attempting to collect a debt, as outlined on this particular slide. Very important to go through it. So although it's not as prescriptive as the FDCPA, certainly there are provisions that are noteworthy and certainly bear on your operations. We often see a claim under J, which is claim or attempt to enforce a right with knowledge or reason to know that that right doesn't exist. And the argument is, oh, you didn't give us a notice of right to cure, so you don't have the right to file a lawsuit because that's a procedural step to filing a lawsuit, or that's a procedural step to repossessing. That question was presented in security finance versus Husch. And in that case, it was alleged that the lender failed to send a proper notice of right to cure, and that the creditor violated the debt collection statute when it filed a lawsuit seeking collection of the debt. And Husch counterclaimed back and said that the debt collection statute was violated because the creditor knew or should have known it did not have the right to file that lawsuit because they failed to send the right to cure. This went all the way up to the Wisconsin Supreme Court. Wisconsin Supreme Court got it right and concluded that the failure to send a notice of right to cure, an alleged failure to do so, does not result in a violation of the debt collection statute. And in doing so, it further characterized that viable claims under the debt collection statute have to involve egregious conduct and behavior. The failing to send right to cure before a collection lawsuit is not egregious behavior. The court pointed in part to DFI's website that gives examples of egregious behavior, including using obscene or threatening language with a customer, calling outside of the hours between 8 a.m. and 9 p.m., demeaning a customer's occupation, things of that nature. So this was really a great decision. Notably, what was not addressed here is whether somebody does something other than file a lawsuit that can be dismissed. So here, the lawsuit was able to be dismissed before a judgment was obtained. What happens if a lawsuit is filed and a judgment is obtained and no right to cure has been sent prior to all of that? It also does not address in connection with the repossession of a motor vehicle after the motor vehicle has been repossessed. All right, Lisa, back to you.
Oh, thank you. And our firm handled this case in the Supreme Court, which we're very proud of. And I had the honor and privilege to argue it in front of the Supreme Court. I do a lot of appeal work, and this is by far my favorite case because we won in a beautifully written decision. And I told the now Chief Justice of the Supreme Court, Annette Ziegler, wrote this decision, and I saw her this summer at the State Bar Convention, and I happened to mention that Husch is my favorite case, but I forgot that she wrote it. So anyway, I think she might have remembered. But anyway, the other thing about Husch that was a really good result for creditors is that the consumer lawyer in that case, and consumer lawyers in many cases we've seen over the years, raised this case of Kett versus Community Credit Plan from 1999. That case is really not very long. It's a Supreme Court decision that involved the situation of a repossession filed, a replevin action. This was before self-help repossessions were allowed. Replevin action filed in the wrong county, the wrong venue, where a judgment was obtained, and then the collateral repossessed. The argument is the judgment was void because it wasn't filed in the right county. In Kett, the Supreme Court held that not only would that be a violation, enforcing a void judgment, it's a violation of 427-104, the debt collection statute. And the court held that it was, without giving it a lot of analysis. We've seen Kett cited many times for the argument that any violation of the WCA, even like a technical violation of notice of right to cure requirement or something like that, leads to a violation of the debt collection statute. And we always push back against that. But fortunately, the Supreme Court in Husch held that Kett should be limited to its facts. It relates to the situation of enforcing a judgment obtained in the wrong county was a violation of 427-104. And the court held that Kett's holding regarding 427-104 is limited to situations where a replevin judgment is obtained and enforced in an improper venue. This court's decision is Kett is materially distinguishable from this case, and we see no reason to extend Kett's limited holding to this factually and procedurally distinct set of circumstances. The decision in Husch was 5-2, and two of the justices on the Supreme Court would have even gone further and overruled Kett, but they didn't get two more judges to agree with them. But Kett has been limited to its facts, which is a great result. The another example of the 427-104 coming up in published Court of Appeals decisions is sub 1, sub 5, reporting a debt outstanding, but not the fact that there's a dispute about the debt. In the Turner versus Jean Decker Buick case, the customer filed suit and said that her bank wrongly reported her debt under a contract to finance a purchase of a car from the dealer. She disputed the debt because there were problems with the car. The bank had a process where it reported the debt to the credit reporting agencies electronically, but its process did not include the ability to indicate on the electronic data the fact that the debt was disputed. So the bank called the credit reporting agencies and said this debt is disputed. But every month the same information was reported, but the information about dispute was not updated. And so the credit reporting agencies' reported information didn't show that the debt was disputed. The court in that case on appeal had reversed a decision in favor of the bank and held that the bank could have changed its procedures and should have reported that the debt was disputed every month when it reported that the debt was out there. And so if it's going to report the debt, it needs to also report that the debt is disputed. And if it didn't update it in a subsequent month, that is a violation of subsection 1F of 427-104.
And we don't see this case being cited in our cases. And we would argue, and we don't think it was argued in this case, but we would argue that FCRA preempts the application of the debt collection statute to hold that this conduct was somehow wrongful.
Definitely. Thanks, Marcy. Kat, on unconscionability under Duncan, a great result in the Duncan decision.
Yeah, so I mean, I think we can agree that the other holding that I covered in Duncan was not so great, but this one was better. So returning to Duncan, the court also addressed a longstanding question of whether a customer may bring an independent claim for unconscionability, or whether unconscionability could only be raised in response to a creditor's enforcement action. And to back up slightly, the Wisconsin Consumer Act under WISSTAT 425.107 provides that a court may hold any aspect of a consumer credit transaction or conduct directed against a customer as unconscionable. And a finding of unconscionability requires the court to either refuse to enforce the transaction against the customer or limit the application of the unconscionable aspect or conduct to avoid an unconscionable result. And additionally, a finding of unconscionability allows for the recovery of $100 from the creditor and actual damages that result from the violation. So, excuse me, the Wisconsin Supreme Court, in citing federal decisions that had looked at the issue, the court held that the Wisconsin Consumer Act unconscionability claims are available only in limited circumstances in response to an enforcement action. The court reasoned that this holding was in line with the common law doctrine of unconscionability, which is a defense to contract enforcement and not an affirmative claim available outside of a contract enforcement or breach of contract action. Therefore, the court held that a claim of unconscionability could only be asserted in response to a creditor's lawsuit to enforce the rights arising from the consumer credit transaction. And the consequence of this decision is also significant. As I said earlier, it resolved a longstanding question about the Wisconsin Consumer Act unconscionability statute. It also brings Wisconsin law in line with federal court decisions rejecting independent unconscionability claims and confines it only as a defense And then with respect to non-judicial repossessions under the Wisconsin Consumer Act, the court held that that wasn't an action or proceeding in which the Wisconsin Consumer Act unconscionability could be asserted because it is an explicit alternative to litigation that does not require the creditor to assert its rights in court.
This was a really, really good outcome in this case. There is a particular plaintiff's attorney who regularly asserts unconscionability. And so the decision by the Wisconsin Supreme Court has been able to reduce the likelihood of that claim in future litigation.
We just want to point out that there is a pending case in the Court of Appeals relating to the collection action, a voluntary dismissal by the creditor, the customer making counterclaims. Factually, procedurally, it's similar to what happened in Security Finance versus Husch. This case is Credit Box versus Weathers. It's pending in the Court of Appeals. It's fully briefed. The Court of Appeals has asked to have oral argument on this case, which is very unusual. It hardly hears any oral arguments any given year. And in that case, which will be argued January 23rd, the consumer's lawyer in that case is the same consumer's lawyer we argued against in Security Finance versus Husch, and the same consumer lawyer who was in the Duncan case. So we see him frequently. In that case, the lender filed a collection action less than $2,000 on the debt in small claims court. The customer disputed it. The customer filed an answer that actually didn't dispute it, but pro se. But then the lawyer appeared, filed an answer, asked to move, and a judgment was entered because the answer didn't really deny the debt. But the consumer lawyer appeared, asked to vacate the judgment, and the court allowed it. That lawyer, the creditor in that case, filed to voluntarily dismiss the action quickly because litigating would be more expensive than recovering its less than $2,000. The consumer lawyer then filed an answer and counterclaims and objected to the voluntary dismissal. The court in that case, the lower court, dismissed the counterclaims and found that they didn't state a claim for relief. And so that's one of the arguments in the Court of Appeals are the challenge to voluntarily dismissing an action when there are counterclaims asserted. In that case, lack of good faith under the Consumer Act, lack of notice of right to cure, which we've seen before, and the issue of unconscionability. The factual question in that case relates to an electronic funds transfer that was submitted and there wasn't sufficient funds for it, and it was submitted a couple times. The consumer is challenging that factually. That's the basis of his counterclaims. And so we'll be interested to see how the Court of Appeals approaches this case and what questions it has in January when it has oral argument. Natalia?
Thanks, Lisa. Yeah, we just wanted to highlight quick the federal bank preemption, which we've seen a couple recent cases in Wisconsin addressing this with respect to the notice of right to cure default requirement that we talked about earlier. And just so you're aware, and this I guess is relevant for both banks and potentially companies that may buy debts from banks because courts have considered some requirements preempted for those companies as well. But in the Western District of Wisconsin, the court recently held that the National Bank Act did preempt the WCA's default and right to cure requirements. But in doing so, the Western District declined to follow a related and very similar decision, or at least factually, from the Eastern District, where the Eastern District concluded the opposite, that the National Bank Act did not preempt the same provision under the Wisconsin Consumer Act. And we just wanted to highlight that for your attention because, you know, this was the same requirement and statutory provision in both cases, but the courts came down differently. So it's something, you know, that needs to be analyzed based on the facts and that are involved in the case and the court that you're in front of. and just trying to figure out, you know, how to predict future courts may answer this question could be differently from how a court has answered it previously. So until potentially the Seventh Circuit weighs in on the issue, we're left with two conflicting district court decisions in Wisconsin, at least.
Great. Well, we ran out of time for questions. I see one question here from a member of the audience, and we're happy to discuss that question outside of this webinar. But we really appreciate everyone's time today. If you do have other questions, feel free to pop it in the chat box or send us an email. We're happy to discuss further. And we are going to have another webinar, a third webinar in this series, and possibly others. So we would love to hear your feedback on what topics you would like us to address. There will be a survey that's sent out after our webinar is done today. You could certainly pop the information in there or the chat box, or send us an email or give us a call, however you'd like to connect with us. We'd like to hear from you so we can make sure we're giving you the information that you need. We're really grateful that you attended today, and thanks so much to Lisa, Natalia, and Kat. I have a few housekeeping items to leave you with. As a reminder, this has been approved for legal education hours, and so you have to click the CEU icon at the bottom of the screen, and a certificate of attendance will be sent to you along with a recording of the webcast. And then be sure to complete our short survey, as I noted. We use your feedback to plan for future programs. So this concludes our webinar. Again, thank you so much, and we hope to talk to each of you soon.